So good afternoon, everyone, and welcome to our fifth talk in the Land Rights Initiative Speaker Series. Before I introduce our speaker for today, Mr. Deepak Sanan, who many of you already know, I just want to say a few words about the work that we are doing at the Land Rights Initiative and the broad objective of our speaker series. So the Land Rights Initiative, for those of you who are coming to our talks for the first time, is CPR's newest initiative, which we launched in November last year. In fact, we celebrated our first birthday last week on Diwali. And the goal behind the initiative is really to build systematic archival and field-based research on land rights issues in the country. And so currently we are housing two projects. The first project, which we call Land Rights in the Scheduled Areas, is essentially where we are studying land rights, particularly those of tribals, in the scheduled areas of the states of Andhra Pradesh, Telangana, Gujarat, and Meghalaya. So 5th schedule and 6th scheduled states. In the second project, we are analyzing a database of 2,500 land acquisition cases that have been decided by the Supreme Court from 1950 to the present, with a view to essentially determining the main causes of legal conflict over land acquisition, and also to see what are the trends across different states. So that's what we are doing at the initiative. Our goal behind the speaker series really is to hear diverse perspectives from multiple stakeholders working on these issues, including academics, activists, people in the government like Mr. Sanan, and other civil society organizations, because we want to generate multi-dimensional and multi-stakeholder knowledge on these issues. So on that note, I'm very pleased to welcome and introduce Mr. Sanan. As he was saying to Shubhagato, I've been pestering him for months because I really think that he has something very valuable to contribute here. Mr. Sanan is Additional Chief Secretary to the Government of Himachal Pradesh, and he has charge of the Departments of Forests, Environment, Science and Technology. In his long career, he has held positions in many sectors, including public finance, rural development, water and sanitation, health, urban development, revenue and power, both in the state of Himachal Pradesh and the Government of India. He's also been a consultant to numerous multilateral development institutions like the World Bank, DFID, IDS, IFAD, the list just goes on. Mr. Sanan has published regularly on center-state relations. In particular, his work has focused on how to create incentives for using central funds more effectively to deliver outcomes. And particularly, he has been interested in the design of CSS, or centrally sponsored schemes. Today, he's going to talk about land titling, which is an issue of great importance and controversy in India. And so without further ado, I want to thank you once again for taking out the time to come speak with us. And I also want to thank Pooja and Pranika, who have been very instrumental in putting this talk together. So I turn the floor over to you now, Mr. Sanan.
Thank you, Namita. We'll try and say maybe spend about half an hour and then we can do some questions. If I spill over, I hope you'll excuse me. The reason for this slightly provocative title was that we do tend to miss the wood for the trees in most policy initiatives in India, in most schemes, in most of our work. We are really actually tilting at various windmills, and titling is just, I think, a very good instance of being the other way, and I hope that somehow I can bring this out in the course of our talk today, and also give some suggestions on what might be better ways forward. There is no gainsaying that it's generally accepted that property title records are in very poor shape in India. This is general understanding that the records also do not reflect accurately the situation on the ground. Results in lots of litigation, of course, but in a sense, everybody points out that this is, and McKinsey's report is one very important, interesting instance of this, or very well-documented instance of that this constrains economic activity, land markets are imperfect and all that. So both for rich and poor alike, I mean, from the perspective of those who would really like very well functioning land markets because they feel that lots of investments can pour in and transaction costs should be lower, etc., etc. There is this whole issue of more certainty in title will really lower transaction costs and make investment more practical. There is the other, the Soto kind of school which says if the poor have more security, have better title, then that will also unlock a lot of capital which we don't even realize is there, etc. But to me the more interesting question, and which we will spend a little time on, is so why are property records poor in India? Some things all of us generally understand why the property records are poor in India, and I hope that some of the things I say will be things which we might know but we don't really internalize how much of a reason they are for poor records in India. Land is a state subject in India, we all know that, and the way property title records have evolved in India is a function of the historical past in various states, of how the British interacted, what was the prevailing situation pre-British times, and then how the British interacted in this context, what kind of settlements occurred, whether it was the Raitwari settlements in the south, the Zamindari in east and central India, or Mahalwadi in other places, and how these have evolved over time and what kind of overlay these had on earlier prevailing systems have to an extent influenced the patterns of how we keep records in India. But broadly, I find that 4 generalizations are possible on the way in which records are structured in India. Number 1, and this is generally understood and realized, entries in property records in India are presumptive in nature. And for those who are not of a legal mind, presumptive simply means that they are presumed to be true until they are proved to be untrue. And so these entries are always open to legal challenge. And if you can demonstrate that these are not factual or these are not accurate, then you can have them overturned, in a sense. Which, as we all would readily agree, is a very fertile ground for a lot of litigation. The moment something is always subject to challenge, and when it does have so much infirmity that the challenge is likely to be sustained, it does mean that it's a ripe ground for huge amount of litigation, which we don't have very accurate surveys or documents, but I read in one of Department of Land Resources publications that 80% of litigation in India is property related. And if that is the kind of numbers, then seriously we should be looking at it more seriously. And we don't seem to be. The second, less easily realized, possibly easy to understand and easy for many people who are in this field, the second sort of reason for poor land records or titling records in India is that pre-independence, the land record evolved as a record of land characterized by agricultural productivity. The basis for making up a land record was that you would levy a land revenue, which was the most important source of revenue for the state. And the revenue would be related to the productivity of the land. So the least productive land had the least value in this framework. What was the least productive land from an agricultural perspective?
Land.
It was land which was given over to habitation. It yielded no agricultural return. So consequently, habitation, land under habitation, or in what was called in many parts of India, abadi de, land which was given over for habitation or associated purposes, was left unmeasured. Had no record of rights associated with it. It was just large numbers, plot numbers, which were unmeasured between them. The parcels between them, the rights between them were not recorded anywhere. In effect, what in today's context is the most valuable land, the land with the maximum number of transactions has the minimum record. Because we didn't do very much after the British left either. So today's most valuable property, subject to the maximum amount of transactions, has in most parts of the country the least record. And no real custodian for a record either, which is legally accepted. The third point I wanted to make was, what happens post-independence? We are thinking on improving the land record or property record is dominated by an agrarian perspective which looks at two things. How do I enhance the security of tenure of those who are tilling the land and are not owners and who are not recorded, and thereby if I can improve their security of tenure, possibly I will improve the amount of investment on land and possibly therefore agricultural productivity. That's one angle, purely economic angle. Of course there is the social justice angle which says I just want to give better rights, more security of tenure to those who are tilling it as tenants or sharecroppers, etc. At the same time, the social justice angle also says that I need to impose ceilings on how much land can be held by people, and I need to redistribute excess land. There are two immediate repercussions for the land records of such legislation, which occurs mostly in the late 60s, early 1970s. The repercussions are quite easy to see. If I today say tenancy legislation in a state like Himachal today says that the moment someone is recorded as a tenant, that person has a right to become owner immediately, overnight. If I record a person as a tenant in the land record, next day that person can put in an application that I want to become an owner, at a nominal compensation will be paid to the owner, and the land will become the ownership of the tenant. This is a legislation widely prevalent in states. If not this, then there is a legislation which says the tenant cannot, the moment the tenant is recorded, forever the tenant shall be recorded, virtually impossible to get the tenant out of that land. In effect, for land record, accurate land records or property title records, I'm creating a situation where tenancy will not be recorded ever in future. And even if I do allow someone to come and till my land, I will ensure that that person is never recorded. Similarly for ceilings, I introduce ceilings, but for all those who want to evade it and have managed to evade it, this means Benami. So Benami records, which means that the record itself does not reflect the accurate position of what is on the ground. On the ground, someone continues to hold on to the land in Benami names, but that person's name doesn't exist. So as I said, for the implications for the record is that my record is poor. It doesn't reflect the position on the ground. The most important thing is that this whole agrarian mindset means I disregard even now the creation of a proper property title register for urban areas where most transactions are occurring. Even after 60 years, I still do not have any structure of a property title register in most states of any kind, even a good presumptive register like in rural areas for urban areas. Virtually no state has it. To some extent, a state like mine does, because we created the same record of rights for urban areas as for rural areas, but then my state has 10% urban population. It's to some extent Gujarat and Maharashtra have, but virtually no other state. What is the fourth point I wanted to make on why we have poor title records? The fourth point is related to the kind of legislation we bring about on the urban side. The legislation on the urban side post-independence is statute which is aimed at very sort of with the best objectives. It's aimed at new urban planning which will be in tune with what we think of as notions of good structures for towns, how land use should be allocated, how towns should be designed and planned. And so we have development plans being made. We have statutes which allow for development plans, which freeze or decide on land uses and say this is the way development will occur. in effect, in a country like India, what we are doing is, we are also saying that if you do not follow this, and if you are out of sync with the kind of development plans which we have said are in place, then you cannot deviate unless you follow a certain procedure and pay certain costs. So we all know what that means. Some of the most scandals, biggest scandals in a state like Haryana next to us occur because of this whole change of land use issues. I mean, the biggest area of rent seeking probably becomes land use changes, which in effect means for the record that if you can't afford that, or if you can just bypass that, you are not recorded in the record at all. So most peri-urban development across Indian cities is not being recorded, is not reflected in any property record, in any record in the country at all today, because it's all without permission. It's either individuals who own land in Abadi days, or who own agricultural lands in the fringes of towns and who built up shops or small shopping arcades, or let out, as in our northern India we call it, वो set बना के किराए पे दे दिए या बेच दिए. Now, these sets in those buildings and different floors and different things are not being recorded anywhere. There is no concept of really recording these in our record. So another huge diversion is, and these are the ones which are getting sold and resold constantly, and we just don't record them. Or you have developers doing this, and I'm talking even about developers who do this with permission. What is happening in their cases is that the permission is granted, entire lands are bought by them, they become single owners in the name of this new developer. Plots which are just reflected in the record in the ownership of one developer. Subsequently, the developer has made multi-story apartments in that, plotted it, sold it. That record, there is no legislation to say, or there is no structure to say how this record will be maintained. It's entirely up to the developer. Across Haryana, this record is only being kept by the developer. The only other records is the deeds-based registration in the sub-registrar's office, which is not a title register at all. The only approximation for a title register we have is the rural land record system. And in that, this will be just one plot which stands transferred to a developer. Within that, it's for the developer to make their own registers in whatever form they like, and on that basis, the deed-based registration is taking place. And we haven't given it any thought how we are going to structure this. The only place I find is that statutory development authorities like, say, Huda will maintain a record. Huda will maintain its property registers, and the prime reason for that is Huda's permission is required for transferring land, for transferring properties within their estates, and therefore they charge a fee for it, and they maintain a record. And because they are statutory government-owned authorities, without their no objection, the registration authorities will not carry out a deed-based registration, so they are able to maintain and update this record. But we haven't conferred any legal sanctity to the kind of title records even these urban authorities are maintaining. It's purely because of practice that this is occurring. And on the private sector side, it's pretty much of a black hole how it's occurring at all. So given this, you can imagine what is the kind of setup we have on title records in India. Maximum. So that's why I'm saying we are, in a sense, we are addressing through rural, and as I'll bring out, that the only real interventions we made over the years in property titling are on the rural side. Most transactions, the poorest record, the maximum transactions, the maximum litigation is on the urban side. So, which is why we are really tilting at titling, because the real crux of the matter is left unaddressed. So what have been our efforts till now at looking at titling in India? A major effort has been a centrally sponsored scheme. Over the years, started in the 1980s, we started with centrally sponsored schemes of what are called computerization of land records, CLR, and carried on to become by 2007 the National Land Records Modernization Program. And what kind of work this was doing? This is mostly trying to say that let's make technology do our job. We'll use computerization to really improve the accuracy of our record and its availability, and that hopefully will sort out a lot of our problems. In a sense, the spending pattern reflects our mindset on this issue in NLRMP from 2007, which says we'll pay, the center says we'll pay 100% for computerizing the record of rights and bringing it into a format which is readily available, possibly on the web in future. And it says that we'll pay 50% for surveys and for land record rooms, etc., and 25% for registration where the maximum transactions occur on changes in the land record and in property titling. What is the progress till now? I just saw a copy of a presentation made day before yesterday in a meeting which the Department of Land Resources. Did some of you attend that? No. There was a meeting which the Department of Land Resources had called day before. Unfortunately, I couldn't be here because it was not possible for me to come down earlier. And they reviewed what has been happening, because the new program which has been launched, and we'll talk about it a little later, is the Digital India Land Records Modernization Program. But they just reviewed what was the progress under NLRMP till now. And they find that, and this is the report, so I'm just very briefly mentioning that it says 27 states report that the computerization of land records has been done. 25 states say the computerization of property registration has been done. 19 states say that only computer-generated copies of the record of rights are now issued to applicants. 22 states say that the record of rights is on the web. 15 states say that the cadastral map has also been digitized. 11 states say that the record of rights and the registration details are both now linked, and the softwares for both the registration and ROR are linked. 7 states say that the record of rights and the cadastral software, the Bhu Naksha as it's called in most states, are now integrated. And so you can theoretically, it should mean that when I apply for a copy of my record of rights, I can also get a copy immediately of my map of the plot for which I've applied. 7 states say that they issue digitally signed record of rights to applicants and issue copies of that. So this sounds pretty phenomenal. I am a complete skeptic on what this means. This really means that we've ticked checkboxes. Very conveniently, various states have ticked checkboxes. I mean, a state like mine can say, yes, our record of rights is computerized. 99% of the record of rights is computerized, but updating how much real time is occurring, I'm a skeptic, even on my state, and which is, I would say, one of the best performing states in India. I think we tend to be out of date sometimes by months in updating, by many weeks. And this is a really well performing state. And our servers are creaking. They can collapse any time, and we are not paying attention to replacing them. So it's still a pretty indifferent game across states. Even more important, as I said, this whole game is being played out on the rural side, where transactions are really much, much less. I don't think even 10% of the transactions are occurring on the rural side. 90% of them are urban or peri-urban. And we are leaving that untouched in all this game. So as far as our centrally sponsored program is concerned, this is a picture. There is, in the last few years, a new entrant in this game. And the new entrant is called conclusive titling. I'm sure especially the lawyers really understand this term very well, what conclusive titling means. And this is the new sort of panacea for our problems, which is being touted across the board. For the last decade or so, I'm hearing now that the route to go is conclusive titling, and we just need to introduce this, and we've sorted out, land market in India, transaction costs, and this is the route to go. So what is it that we are really saying? For those of you who don't understand, I'll just briefly say, and we can address it in questions later if you like, that basically conclusive titling is something which is based on something they called, what is being talked about is something which is based on a Torrens system. Torrens was a governor of the state of Victoria in Australia in the 19th century. He introduced a concept where he said, let me say that these are the land grants which were given in the state of Victoria in the past. I don't want any litigation on this, and I want to create a title register for these grants. So what I'll do is I'll go back and see whatever transactions have occurred on this, and we'll update it, we'll sort out all the disputes, and we'll have a title register for the future. Basically used something which was used in the ship registers from I think the Dutch. The Dutch maintained very good registers of ship ownership, used that on the land grants in Victoria and created an up-to-date title register, and this became popular in various places across the world and has been slowly introduced in many countries. But just to bring you into the picture, even the UK didn't have conclusive titling till 1990s. It's not really such a simple thing to introduce in a country which has a huge history of transactions and has changes and occurring over time. It really is a very complicated exercise of settling every kind of dispute, because what it's saying is that here is a title register which is an 100% accurate reflection, mirror of the situation on the ground. What is on the ground is what is on paper, is what is on the net in the title register, is completely a reflection of the position. So to get there means that I have sorted out every dispute relating to that land. I made sure that it's completely accurate, it's completely up to date, and it is just no way that there is any dispute left on this issue. So you can imagine what kind of job it involves to get there. So mirror principle, and then they say once you've reached this, you have drawn a veil over the past. There's a curtain, and this register can no longer be questioned. It's the final. And just in case someone does manage to ask a question about it, then the state is guaranteeing that if there is a problem, then we indemnify. Because we are responsible for this title register, we vouch for it completely, and if there's anything left out, then we will indemnify anybody. So you can see how unrealistic it is to assume in a country like India that you can suddenly have conclusive titling and you can really bring to a halt all litigation and dispute overnight, or even in a very limited time span. This realization seems to have come that conclusive titling is not in most of India something which we can just wave the magic wand and bring about, or we can just create one more dispute resolution machinery like the many we have created in this country, the various tribunals and courts, and it will suddenly bring about resolution in a very limited time frame just because we say so in law. So where are we today? Having come to this realization, I think I'm saving time, or am I doing all right?
You're doing fine.
Fine, okay.
Yeah.
So what we have today is that we have conclusive titling very much in the forefront. We have the whole Make in India campaign has behind it the ease of doing business concept of improving that. And if we look at the ease of doing business parameters which the Ministry has sent out to across states and everywhere, I think about 100 odd things they've listed for various things, and one segment of that is conclusive titling. That this is really important. We have to get there if we have to have a better environment for ease of doing business. So while the Ministry of Industrial Policy and Promotion, the DIPP has this ease of doing business, and Amitabh's people have broadcast this all over. I still haven't seen a word of any note on this from the Ministry of Urban Development, which is really where the real crux of the issue is. As I said, we have, fortunately, a lot of activity on the rural Department of Land Resources side. And I think indirectly they're hoping to address the urban issues, but not really. It's not in their mandate, so I don't know how much will actually end up. So today we are at a situation where the DOLR has sent out 2 consultations, sent out 2 sort of draft ideas for consultation. One on what they call the Digital India Land Records Modernization Program, the new incarnation of the NLR, National Land Records Modernization Program of old. And this is a work in progress. They've asked for views on this. So I'll deal with this first very briefly and say, what are the issues they are really looking at? And I'm very happy to point out first the positives. And the most important positive about the new consultation presentation they made is that they are saying, should we be funding these components and inputs of, computerization of the land record, surveying efforts, or registration work, or land records, record rooms, etc.? Or should we move out, and should we therefore start funding outcomes? I think that's a huge positive, to start focusing. You want to say something?
It means the government.
Yes, the central government. Yeah, the central government. The central government is asking this question in its draft consultation note, that should we be funding components or should we be funding outcomes?
Outcomes being conclusive titling.
Now that, Kiran, is a very interesting question. That is precisely a question which I have in this. The hint is in the presentation that they mean conclusive titling. They seem to be hinting that the outcome which we need to focus on, because that's what Make in India says, that's what we need to do, is that let us move towards conclusive titling. This effectively means that we can end up again missing the wood for the trees. Because in pursuing conclusive titling, what we can end up doing is, we can end up saying, can you show progress towards conclusive titling? Again, we'll end up showing progress in terms of processes, of components, of inputs, and which will be again a ticking of checkboxes. And we'll say, I did this, I set up a machinery for doing this, for dispute resolution. I set up a centralized authority for a title register. But how much closer am I to the concept of property disputes being resolved? And most important for me is that even if I look at and say, yes, I'm declaring entire areas, say, as areas which are now have a conclusive title by statute and cannot be questioned, these are likely to be areas which didn't have disputes anyway, because those are the ones which are going to be most amenable to an immediate title register being publicized and statutorily being announced, is areas which never had disputes anyway. So what am I really achieving by doing this? So I feel that it's important to point out to Government of India and to the Department of Land Resources that don't end up again missing the wood for the trees. It's really about litigation in the final analysis. Are we going to reduce litigation? Are we going to really look at the backlog of property-related litigation and the institution of new property-related cases? How do we mitigate that? How do we ameliorate that? Is something which states need to focus on, and each state will have to look at its own situation to see what action it should take in that ground. So possibly the indicator we need to be looking at is are we moving towards reducing backlogs of property-related litigation and slowing down the growth of new institutions rather than looking at the input of conclusive titling, which will bring us, or the output of conclusive titling, which will bring up this outcome? So really, the ministry and Government of India should be looking at, and this is regardless of sectors, but since we are talking about titling today, we should be looking at the databases for evaluating this. And the databases are, in this cases, we don't even have that database. And we need to start building these databases on what are property-related litigation in India, what is the extent, what are its typology, how can we classify this. Let's just start with the Supreme Court and the High Courts. If I'm not talking about going down to, the 3.2 crore cases in subordinate courts. Let's just start with the Supreme Court. We can go down to the High Courts, and we can probably start indexing states on what is their levels and start seeing improvements and rewarding those improvements relatively between states. So that relatively, I feel that every year we should start rewarding, because one of the biggest problems as a civil servant I have seen after 35 years is the spend pressure of CSSs. There's always a pressure, just spend. Get it out of the way before 31st March. Both states and center combine in this effort. Then let us start reducing all the conditions. Let's start putting away the conditions, or at least ticking the check boxes. But we have to spend. So we must recognize that the spend pressure is an important factor of life in this country, and it will continue to be. And therefore, how to mitigate this in a performance-oriented system? Don't let ticking off check boxes be the criteria for rewarding performance. Let it be a proper indicator. Let me see performance in that, and let me just reward relatively, so that if I have 1,000 crore allocation for the year, let me get all the 1,000 crore out. I shouldn't, as a central ministry, feel I can't afford to save, but these guys have not performed, and what am I going to do? Let them give it away relatively in better performing states every year. I have some views on it. I can explain how this works in questions when we come to that. The most important point I wanted to make is, the moment I focus on property-related litigation, I bring in the urban into the CSS. Without having, even if the Ministry of Urban Development is silent, even if it doesn't want to do anything on this area, if it only wants to start talking to local bodies and say, create property title registers, which is what they're going to end up saying, and which is pretty meaningless in my view, just said like that. So this kind of CSS can bring that focus purely because where the litigation is in urban. The second consultation paper, consultation idea which the Department of Land Resources has brought out, is on conclusive titling. And I'm very happy to say that they have realized, and they implicitly, because it's probably politically not correct to say that this is a harebrained idea. So, DOLR cannot afford to say it, that to try and bring this out, in a very limited time span, and to say that we are going to do it is probably harebrained. But they are implicitly recognizing this, and I'm very happy to note this in the new consultation paper by saying there are various options in conclusive titling. It's not just about comprehensive, immediate, statutory conclusive titling at one go. So they are talking about, one option is compulsory conclusive titling at one go, but the next option is incremental compulsory titling system, where every time you come for a title registration, we will start then doing something like a title search immediately. Then we'll start moving towards dispute resolution on all the disputes which are pointed out in that, and bringing it to fruition, and then saying, so now this is conclusively settled for this property, and so this comes under the ambit of of a statute which we've already put in place. The third option they give is, let's not make it compulsory at all. Let's make it optional. If someone says, I want to come under the ambit of a conclusive titling regime when I come for a title registration, then we'll do this exercise for them and we'll bring it. And finally, the fourth option they say is, let's move incrementally geographically. So there may be areas, there may be developers, like I said, this, say, a Huda colony, which has a very good title register, or an apartment block act in Maharashtra, which ensures that really titles are settled before that plot is given to that developer, that before the developer can start work on it, then the developer maintains an excellent title register of their own, and let us move towards making these title registers into a conclusive title register. And so you start and you expand this sphere over time. So they're giving these various options, and really what they are asking for views from the states is on one issue, and the primary issue is, should the center legislate to bring about such legislation, giving sanctity to such legislation at state level for conclusive titling, by bringing in a new legislation which in a sense bypasses and says we simply override any constraints placed by existing statutes, whether the statute is the Transfer of Property Act, is the Evidence Act, it is the Registration Act, the whole sort of gamut of legislation since the 19th century which deal with property titling in direct or indirect ways, and we just override it by having a central legislation which facilitates states to bring in possibly their own systems. Or should we not do this and have a flexibility? My personal view, and I'll end with that, is that I would rather not have a central legislation. I think this is really a vast country, and I have seen over the years every bit of central legislation of this nature ends up just complicating and creating more litigation. We cannot address the whole gamut of issues which arise and which come up, and therefore I would go with a view that let the center just bring up a guidance note, say think of addressing these issues if you want to go move towards conclusive titling, bring up your own legislations, and we will at the central level, because if you're conflicting with state with central legislation in your legislation, you have to send it to us for assent, and at that stage we will address it. And every state's conclusive titling legislation which comes up before us, we, like the labor legislations of Rajasthan, we will look at it positively, we will give our assent and make sure that they come on board. So in a sense, let really cooperative federalism move on this area also, in terms of letting states in a sense make decisions. So I'll end with that and say that if we can combine this with an effective incentive through the CSS on dispute resolution, with a flexibility and guidance to states to bring up legislation and move towards these areas, which automatically is favoring getting rewards from the CSS, I think we could make progress in the coming years. I'll end with that and open to questions.
Thank you. Thank you so much, Mr. Sanan, once again for, as always, being insightful and thought-provoking, and for saying it as it is and not being politically correct. So we'll open it up for questions now. I'll keep a tab